All right, so this week we are looking at the court system. We looked at trial courts on day one. We talked about their makeup, plaintiff, prosecutor, defendant. We looked at juries. We talked about juries. Day two, we went through the steps of a trial. Okay. And today we're going to focus on appeals courts for one thing, as well as some other types of courts within this whole umbrella of trial courts, period. Okay. So we've gone through the trial, there's a verdict. Now, let's say one side is upset with the verdict. Do they have the right to appeal? Yes. This is when appeals court comes into play. Now, what is an appeals court? An appeals court, one party presents arguments asking the court to review the decision of a trial court. The other party, of course, is going to present arguments supporting the decision of the trial court and saying, no, we do not have to have this decision reviewed. There are no juries or witnesses. No new evidence is presented. It is only lawyers that appear before the judge to make legal arguments. Okay? Now, for an appeal to go forward, you must show there has been an error of law. An appeal is possible only when there is a claim that the trial court has committed an error of law. Now, what is an error of law? That occurs when the judge makes a mistake as to the law applicable in the case. Okay, we talk about those jury instructions that are given. If the judge gave the jury the wrong decisions, or I'll take it this way too, if a judge does not do his job and keeps both sides in line, okay, because remember, the judge has the power to keep the defense side or the plaintiff or the prosecutor in line during the trial through sustaining and overruling and things like that. If the judge doesn't do his job and prevents one side from breaking the law or gives the wrong instructions to the jury, then an error of law has been made and you have the right to appeal. Okay? Now, errors are minor as long as it does not affect the outcome of the trial. All right? If the evidence still stacks up against the defendant or against the prosecution of the plaintiff, and the judge doesn't do something, chances are it's very, very minor, and it's not going to impact the outcome of the trial. Okay, errors only become major if the outcome is affected, and of course, it is up to the party that is bringing the appeal to the court to prove that it did impact the outcome of the trial. Okay. If errors are minor, the trial court decision will not be reversed and the appeal will not be granted. Okay? Now, let's say, well, before we do that, we defined a term in chapter 1 called precedent. Okay? When it comes to appeals court, precedents are very, very important. Precedents are those written opinions and rulings from similar cases that impact decisions in the future. Okay, remember, they are from past cases, but they impact decisions in the future. Higher courts will go to these precedents in order to determine if an appeal should move forward or not. Okay, now a higher court can reverse or change precedent. Remember, precedents are not set in stone. We've looked at that with Brown versus Board of Education. We've looked at that with prohibition and things like that. So precedents can be changed, but higher courts will go to precedents to decide whether or not to move forward with an appeal. Courts in other parts of the country are not required to follow precedent. It tends to be a good idea because you want your legal system to be legitimate. So if you're basing your ruling on well-established precedents in other cases, that is a good thing. You're not required to, but it is a good thing. Okay. Courts in other jurisdictions or states can disagree with a precedent. All right. We saw that with Plessy versus Ferguson. Okay. That seemed to be a bigger deal in the South than it did, say, in the North. Okay. Even though the Supreme Court was handing down Plessy versus Ferguson, you saw very few people in the North having separate but equal faculties. Okay. It was supposed to be all equal. Okay. Okay, there was no separation. Now, in an appeals court, you appeal before a panel of judges. Sometimes three or more. Sometimes it could be one, but sometimes three or more. If it's the Supreme Court, it is a 9-panel judge, and the Supreme Court is a court of appeal. We're going to spend tomorrow or our last lesson talking about the Supreme Court. So more on the Supreme Court later. Okay. Now, if judges disagree, two or more written opinions may be issued in the same case. All right. So if you go to an appeals court and a judge disagrees or two judges disagree, they will write an opinion explaining why they disagree. Okay. Now, with that opinion comes two important terms, and I want to be sure you get this. The majority opinion states the decision of the court. All right. So majority opinion rules and states the decision of the court. If you have a judge disagree, they write opinions. Those opinions can be either dissenting or concurring, okay? And I want you to get these two terms down. A dissenting opinion is judges who disagree with the majority may issue a separate document, a dissenting opinion, to state the reasons for the disagreement, okay? Now, this happened with Plessy versus Ferguson. Some of the Supreme Court justices disagreed with that, and their opinions became precedent for Brown versus the Board of Education. Okay, it was a future majority opinion. All right, so a dissenting opinion, if a judge disagrees with the ruling, it's a outright disagreement. This is why I disagree with it. Okay, based on my understanding of the law. Okay, now you can have judges disagree, but for different reasons. That is a concurring opinion. Okay, they agree with the majority, but they agree for a different reason. Okay, so they write a concurring opinion. I agree with the majority, but it is for a different reason. Okay, it is for a different reason. And I cannot think off the top of my head of an example of a concurring opinion. It would have to be based on the Constitution. All right, based on my reading of the Constitution, I agree with the majority, but I agree with them for this reason, not what they are stating. Okay, so dissenting opinion, you just outright disagree, period. A consenting opinion, you agree, but you agree with a different reason. Okay. Now, that's it for an appeals court, all right? So, if you go to an appeals court and you make it through, all right, and the judge says or the judges agree that a error of the law has occurred, all right, the case will get heard again. All right, it could get heard in front of the appeals court. It could go through another trial court. All right, one more time. All right, so if you win your appeals, the case will be heard again. Now, under this trial court umbrella, there's some other courts we want to talk about. The other court are state courts. Okay, now I'll go through these real quickly. State courts are courts of general jurisdiction. They hear cases that deal with state law as well as many areas of federal law. Because remember, the states have certain powers granted to them by the federal government that overlap with federal government powers. So state courts can hear cases of federal law. They are also most definitely going to hear cases of state law. All states have trial courts. They're superior trial court, county, district, and municipal. Some of your lower courts, like the municipal courts, are specialized to deal with specific issues like family issues, traffic court, criminal probate, small claims court, etc., etc. Juveniles are in a separate court system altogether, juvenile courts, okay? And that falls under this blanket of state courts, okay? So if it's a case involving a juvenile, you go through the juvenile court case or the juvenile court system. Also under state courts, they are criminal courts. There are cases involving violation of law in which violators could go to jail. All right, divided between felony and misdemeanor. We talked about felonies being your serious crimes with serious punishment. Misdemeanors are your less serious crimes, punishment of less than a year. Okay, so they are criminal courts under the state courts. I want you to get down this term, probate court. A probate court handles cases involving wills and claims against estates of persons who die with or without a will. Okay, so when you pass away, your will is handled by a probate court. And if you pass away and you don't have or your will is challenged or you don't have a will, that's also going to go to a probate court. If you lose your case in a trial court at the state level, okay, you may be able to appeal to an intermediate court of appeals or to the state's highest court. Okay, so at either one of those levels that we just talked about, Superior Court, County Court, District Court, Municipal Court, you may be able to appeal. You can go all the way up to the state Supreme Court. Okay, and there are state Supreme Courts as well as the national Supreme Court. If a state Supreme Court decision involves only state law, it cannot be appealed. However, if the state Supreme Court decision involves a federal law, you could appeal all the way up to the U.S. Supreme Court. Okay, so if we're dealing with state issues, you stop at the state Supreme Court. You can't go any higher. If we're dealing with federal law, federal constitutional issues, federal issues, even at the state level, you can appeal to the highest court in the land, which is the U.S. Supreme Court, but that is only for federal issues. It does not apply to state issues. Now, what about these federal courts? Okay, what about these federal courts? Again, we're under the umbrella of trial courts. Federal courts are courts of limited jurisdiction. They can only decide certain cases. They will hear both criminal and civil cases, but they hear criminal and civil cases involving federal law. If it is a civil case, it has to involve people from different states, and the amount in dispute is more than $75,000. Okay, so if it's less than $75,000, it probably will not be heard in a federal court. Federal trial courts are also known as U.S. district courts, and there are 94 total around the country. If you lose in a U.S. district court, okay, your appeal can go to the U.S. Circuit Court of Appeals. There are 13 total of those. If you are unsatisfied with the Circuit Court of Appeals, then you can appeal to the Supreme Court. Okay, and be sure you get down those totals. There are 94 district courts and 13 circuit courts of appeal, and then there's only one Supreme Court. Article 3 of the Constitution creates the Supreme Court and gives Congress the power to create lower courts. Now, we'll talk more about the Supreme Court tomorrow, okay, in the last lesson. But one of the things as we go through this semester, we're talking about how do we get the laws and how do we get our legal system? Well, Article 3 of the Constitution creates the Supreme Court and gives the power to create lower courts. If we're dealing with those district courts, they have at least 2 judges. Some have more than 20 to handle all the cases. Besides the district courts, you also have federal bankruptcy court and tax court as well. The circuit court have between 10 and 15 judges, all right? And I'm not so much concerned about the number of judges. This is just kind of for your information. I do want you to know there are 94 district courts and 13 circuit courts of appeals, okay? The U.S. Court of Appeals for the Federal Circuit is in Washington, D.C. It handles appeals from federal courts all over the country, okay, and deals with issues like international trade, patent law, money claims against the federal government, and veterans issues, okay? So you got those 13 courts of appeal, and then here's another one that's over all of those. All right, so it will hear appeals cases from all of those. There is also a U.S. Court of Military Appeals that deals specifically with military court and military issues. Okay, now these federal courts are kind of a big deal. I'm going to go through these real quick. Sorry about that. They handle more than 300,000 cases per year and about 1 million bankruptcy petitions. Okay, compare that to state courts. State courts here, 35 million cases a year. Okay, so federal. The idea is to keep the federal courts free. They hear 300 cases a year compared to state courts that hear 35 million. There are 1,700 federal judges. There are 30,000 state court judges. Federal court judges are appointed by the president and confirmed by the Senate, again, thanks to the Constitution and the balance of power and the checks and balances between the different branches. Federal judges serve until they resign, retire, or die, so it's an appointment for life, all right? And you can either decide to resign, retire, or you pass away. To remove a federal judge requires Congress to follow formal impeachment procedures, okay, which is again one of those checks and balances. We don't want politics involved, and I'm just going to get rid of this judge because I don't like the party that they belong to. You can't do that. There has to be an official reason, and you have to follow formal impeachment procedures. Okay, so we got state courts, we got federal courts. We're also going to talk about tribal courts real briefly, okay? Now, I do want you to get down those two terms that are highlighted there. Tribal courts, and we talked briefly about these in chapters 1 and 2. They deal with Native American issues, all right? Native American tribal courts are no longer completely independent sovereigns. At one point in time, they had more power than they do today. They no longer possess complete authority. They still have some power, but they don't have as much power as they once did. Now, that being said, I'm going to jump down to the bottom. They can hear a broad range of both criminal and civil cases, but just keep in mind they don't have the power that they once did. Now, the power they do have is divided into inherent powers and delegated powers. Inherent powers are their power by virtue of the fact that they are dealing with tribal issues like family relations, tribal membership, law and order among tribal members on the reservation. Okay, so by virtue of the fact that they are a tribal court dealing with tribal members, that gives them certain powers. That's inherent. Sometimes they are granted powers by Congress, by the Constitution. That is a delegated power. A granted power is a delegated power. For example, their power to deal with environmental issues, which traditionally could be handled by the EPA. All right. The fact that tribal courts can handle or can deal with some of those issues, that is a delegated power. Now, tribal courts strongly reflect the culture of the people who work in them. All right. Pueblos are very, very traditional, and they show very, very little influence of American culture. Some other tribes, you're going to see more of an influence of the American legal system. Jurisdiction varies based on such factors as the location of the offense and the status of the defendant and the plaintiff. Okay. Here is where we begin to see a shift in power. At one point in time, and I think I mentioned this in one of the earlier lessons, okay, if it happened within tribal boundaries, the tribal council, the tribal court dealt with it. That would include things like murder. Not so much anymore, okay? Criminal area, the federal law gives federal courts jurisdiction over many felonies committed by Native Americans on the reservation. So these two things go together. That's what I'm trying to get at. At one point in time, a felony that was committed within the tribal boundary was dealt with by the tribal court. All right. Now, okay, based on the status of the defendant and the plaintiff, and it used to be if one of the people involved was not a tribal member, then the issue had to be handled in a federal court. Okay. Well, now federal law says, you know what? If we're dealing with felonies, it doesn't matter who's involved. It can be two tribal members. It could be one tribal member and one outsider. Okay. It doesn't matter where it happened. If it's a felony, the federal court is going to deal with it. Okay. And at one point in time, everything was handled by the tribal court, but not so much anymore. Okay. Even if the tribal court handles the case and they find the person guilty, criminal sentencing is limited to imprisonment for no longer than 1 year and a fine of no more than $5,000. So here's another way that the tribal court power has kind of been whittled away. At one point in time, they could pass down any judgment they wanted, no matter how long or how much, but not anymore. Okay, the federal government has said you cannot imprison somebody for more than 1 year, and the fine cannot be more than $5,000. Now, tribal courts no longer include the authority to prosecute non-Native Americans for crimes committed on the reservation. I talked briefly about that just a second ago. At one point in time, tribal courts handled everything. Now, if the defendant or the plaintiff or the prosecutor is definitely a non-Native American, it goes straight to federal court. Okay, the tribal courts no longer have the authority to prosecute non-Native Americans for crimes committed on the reservation. The power of tribal court to hear civil matters on the reservation appears to be very broad. That's principally where you're going to see the issues brought up. If we're dealing with criminal court or criminal issues, chances are it's going to be handled by a federal court and not a tribal court. Okay. Well, that's it for some overviews, real quick overviews of some different courts within this umbrella of a trial court. We talked about tribal courts, we looked at federal courts, we looked at state courts, and we looked at the appeals court process. Where we're headed next is we are going to talk about the Supreme Appeal Court in the land, and we're going to talk about the Supreme Federal Court in the land, namely the Supreme Court of the United States. And we'll wrap up, because the Supreme Court is such a big court, we'll also wrap up our discussion of tribal courts by looking very, very briefly at some international courts as well. And that's in the next lesson, which will be the last lesson for the week.